Thank you. It's a real pleasure to be here, and our group was very interesting, to say the least. I also had the side benefit of having a lot of fun lawyer jokes during the program, too. But given the time that we had, we couldn't answer all those provocative questions that were assigned to us, so we did tend to focus on certain areas, which I will summarize here. The legal system, which was so clearly spelled out by Lori Stiegel earlier, tends to really, or at least traditionally, be involved kind of later in this picture and involved with secondary and tertiary interventions rather than primary interventions. But that's partly because there's not a lot of thought that has gone into the primary intervention side, which focuses very heavily, which would need to focus very heavily on education and training and the competencies needed both to screen and spot abuse and exploitation, as well as to address it early on, to, in many cases, divert it from the legal system. And the stakeholders that really need to be targeted in that are particularly police, prosecutors, and with respect to prosecutors, we do know that units that have been set up as special prosecutorial units in aging have been very effective. They just are not very widespread. Certainly, judges need to be trained. The typical judge across the country is in a court of general jurisdiction. They're hearing all kinds of cases. They don't really hear these kinds of cases. They don't even hear guardianship cases very often. And so when they get them, you're really starting with a blank slate very often with the judge. And then, of course, the players that are connected to the legal system that are important partners with them, like protective services and financial institutions. With respect to training and particularly screening, I mean, there are examples from other fields. Don Blandon from the Investor Protection Trust gave a great overview of the program that they developed through Baylor for teaching physicians to be able to spot the patients who are at risk for financial abuse. And those kinds of programs could pretty easily, I think, be translated to lawyers and other parts of the legal system. The legal system, it has, especially the courts, often have a very insular culture, and they're not naturally inclined to go out of their comfort zone. So it really takes a lot of players from many sources pushing in. A second area that we talked quite a bit about was area of guardianship and conservatorship. I mean, it's seen in legal theory as a remedy for abuse and neglect and for problems of incapacity, but very often it is more part of the problem than it is part of the solution because it is often overused. And the courts tend to see capacity and guardianship, despite the fact that all our state laws now really try to push the concept of limited guardianship. Courts still see it as a black and white kind of choice, and get through it quickly without giving it a due assessment. So often guardianship becomes a source of abuse rather than a remedy, and particularly at the front end, other diversionary intervention resources could be extremely important to the legal system, but are generally underfunded and under-resourced. Particularly APS is certainly underfunded. And other resources such as civil legal services that specialize in elder abuse are largely absent. Pro bono programs that specialize in elder abuse. And among the private bar in general, there's often a lack of structuring of various legal tools that should be preventing elder abuse in the first place, particularly around powers of attorney and legal tools like that. And part of it is because the laws in many states are weak, and part of it is because lawyers aren't well trained to think of elder abuse, preventing elder abuse, at the time they're counseling clients on estate planning. And expanded use of ombudsman program in community settings is starting to happen out there. That's another adjunct resource that could be very helpful. And there's also, along with these resources in the courts, the lack of knowing what happens to these cases in the courts is a chronic problem. We have very poor data systems. They're variable all over the country, and they tend to focus on the front end, how many such and such kind of cases were filed. But we don't know what happens to these cases after they get into the system. And finally, the last area was institutional abuse, and the need for expanded resources around, such as the Ombudsman Program, the Long-Term Care Ombudsman Program. One suggestion was that probably the biggest single thing you could do to cut down, to prevent abuse in nursing homes is to mandate minimum staffing ratios in nursing home settings. And we already heard in the program about state fraud and abuse units that have done some great things where there are systemic problems with abuse. But that was the third area. And let me just end with saying, connecting all these things is what? Not a lot. As I said, the legal system can be very insular in its culture, and the use of tools such in communities such as multidisciplinary teams is really a vital method of breaking down those barriers and getting the lawyers and the judges to actually come in, get educated, and to begin thinking in more productive ways. Thank you.
Thank you very much. I'm going to switch the order a little bit here because our final panel is going to be split between two speakers. So next up, we're going to hear about the financial sector. And I have the pleasure of introducing Naomi Karp. I'm sorry she doesn't have a name tag here. She thought she was going to lunch and attending a breakout group. And here she is, our favorite volunteer at this meeting because she's now on our panel. So I have the pleasure to introduce Naomi Karp. She is an attorney at the Consumer Financial Protection Bureau in the Office for Older Americans. Naomi?